judge. It gets you nowhere. Just a simple objection is good enough. Okay? He wants to shut you down, that's just fine. That's because he knows you objected to everything, and so forth. Now, if the record is not being properly kept, you know, you go back and you look at the docket and you see stuff that's not on there. All you have to do is file affidavits relating to that hearing, and you say this is what really happened. And ideally you should have 2 affidavits. 2 different people, okay, behind you at your hearing who saw what went on will each make up an affidavit of what they observed, and when you file those in, that makes the record too. Okay? And then you issue the orders. The orders are, whether they're ignored or not, they build the record. At some point, the weight of the record, the conceptual weight of the record, is what wins. That's all there is to handling the judge. Okay? Yes, sir?
What if there are 2 witnesses there present?
You're in trouble. Do the best you can. Yes, sir?
You said the judge is your subject.
That's right. Everybody's your subject if you're the plaintiff.
And then that brings in light Georgia. Chisholm versus Georgia says the people have no subject.
Well, he says the Chisholm versus Georgia says the people have no subject. Well, that's true. The people do not have any subjects. Okay? Hang on here. You don't have any subjects normally, but when you do get a relationship going, you know, you're the plaintiff, the defendant is always the subject of the plaintiff. Always. That's the relationship. You know, and if you are the defendant, you must convert yourself into a plaintiff. Okay, the way you convert yourself into a plaintiff is you file a counterclaim or you file a habeas corpus. Either way. Those are the only 2 methods I know for converting yourself into a plaintiff. If you filed an original lawsuit, you're obviously the plaintiff. But you file a counterclaim. The counterclaim absolutely must be based on a challenge to jurisdiction. When you challenge the jurisdiction, everything must stop in the other court until they prove their jurisdiction to your court. Okay, they have to prove it to your court. They can't just say, oh, I'm wearing a robe. That's what one judge told me. He says, well, my robe is my jurisdiction. Okay. But, you know, the jurisdiction is the basis of your counterclaim, and that makes you the plaintiff. And now what do you have? You have plaintiff versus plaintiff instead of plaintiff versus defendant. Now you know, you're now the counter plaintiff, and you have the counter defendant. You've converted him temporarily into your subject. Depending on the outcome of that case, that may or may not be the death of the other case. Okay? Here.
Joe had asked you when people ask questions for you to restate the question before you answer.
Do you want me to restate that question? Okay. Do you want me to restate that question?
Yeah, please.
He says that when he wants me to restate the question when the question is asked or the point made. So I just did. Okay.
Okay, when you file that counterclaim, you do not ask for any monetary, correct?
When you file a counterclaim, you don't ask for monetary. That's not true. The whole idea of a counterclaim is that you've been injured by them taking jurisdiction when they shouldn't have. And you're challenging their jurisdiction. And if you've been injured, obviously you want the compensation for your injuries. You betcha.
Okay, if it's a criminal, you still have to file
Is that on?
a counterclaim similar.
Is that mic on?
I don't know.
If a counterclaim, look, we filed a counterclaim just recently. In the Los Angeles court. The Los Angeles court is so large, the left hand doesn't know what the right's doing. So I attempted to file it with the criminal courts. They wouldn't accept it. They said, this is civil. Well, technically they should have accepted it, but they're ignorant. So, as long as your rights are not given up, go ahead and go along with their ignorance. Okay? Doesn't hurt a thing as long as you're retaining your rights. So what we did, we said, okay, you don't want like that? We'll go over to civil. Went over to civil. I had the proper format for counterclaim. They didn't like that. You say, well, you got to be the plaintiff. I said, okay, scratch out this part. All right? So I scratched out the original criminal heading, which was state versus defendant, and the lower heading was the defendant, now a counter plaintiff, versus the counter defendant. That made the clerk happy. Okay? And then it said on the other side, on the right side, it said counterclaim. He didn't like that. I said, okay, scratch it out, and I hand wrote complaint. Now he was happy. Now, why is it that I was able to do this? Because titles and headings do not control. What controls is what's in the body. The clerk never looked in the body. He only looked at his customary headings, and he was too ignorant to know what the alternative procedures were, and I didn't want to hassle going up through the supervision and all this sort of stuff. When it, you know, I have now adopted pretty much a policy of just rolling along with them as long as the basics are not messed with. I don't worry about the details. As they say, don't sweat the small stuff, okay? And so when they filed it in, and one of the demurrers that we got back on it, by the way, the guy complained about how all this stuff was scratched out, and he's confused. He doesn't know who's defendant, counter defendant, whatever. Well, it's a personal problem attorneys have.
Okay, to follow up though, the next step, if there are damages involved, should you make the damages high enough to go to the next level court so you're not in what was a muni court previously?
No, you should never do that. What you should do is claim the actual damages, whatever they are.
What?
Well, it's up to you.
Okay.
You know your injury. So
back to requiring 2 witnesses with you. If you can't get the 2 there on that date, can you request from the court a audio recording or a video recording of the proceeding? I
don't know what their policies are, but one of the things when I go to court, and if I don't have 2 witnesses with me, well, that's too bad. I mean, you do with the best what you can. You've got court reporters there typically. I understand that court reporters do not always properly report what was said. That happens. But they usually leave enough in so that you can hang them. So, but they do, you do the best you can. You know, you deal with reality. If you can't get people to back you up and be your witness, well, then that's how life is. But you make your effort. Remember this, once you're in charge, you got a lot of flexibility. Yes, sir.
Bill, I had a question. The judge we're dealing with in Oklahoma will not give us an oral hearing of any kind.
He doesn't have to.
So in lieu of being able to say these things in court, you just put it all in writing?
No, it isn't in lieu.
Oh.
It's what you do.
I see.
You always put it in writing.
Okay.
You see, if the judge, like as you said, the judge won't give you an oral hearing. He doesn't have to. That's purely the discretion of the court. Okay? When you file your papers, you need to look at the DVD, which you can get from Dennis Wilson. Whipple. You get it from Dennis Whipple, right here, who's handling this. Yeah, you can talk outside. So but Dennis Whipple has copies of the DVDs from before. Let him know that you want the other DVDs. You can get them. I don't know what he's selling them for. Now, the DVD you get for today is free. It comes with the package. But
if you attended last time, it was free too. So.
Oh, if you attended last time, it's free. You should have one. But I went into all the details about how hearings are in motions. But bottom line is that when you make a motion, you've got to have your affidavit of facts. You have to have your points and authorities, also called a brief, where you argue your case, and that's the actual hearing on paper. That's your brief is your hearing. Say what you got to say then, it's purely the discretion of the court whether or not they have any questions to ask you. Once you have that hearing, you're not supposed to introduce anything unless the court asks you. Okay? So, in fact, if you file your papers and don't show up at the hearing, then you still made the appearance. Now, that's if you're on the defending side. They do a demurrer or something like that. Yes, sir.
Another question is,
My understanding from what I've read so far of your work is that you talk about a court of record. Well, at this point, we know nothing's on the record. There are only things that are in their file.
No, you have a wrong conception of what a court of record is. Have you been to the website?
Yes.
Okay.